We are on the last segment of the memorandum and article. That is, we just need to discuss two, three doctrines and a basic procedure of alteration in memorandum and article. Now, two doctrines are there. First is the constructive notice, and second is the Indore management. Doctrine means the principles, right? Constructive notice. Constructive notice simply means that once the company is incorporated, the memorandum and articles are public document. Now, suppose I am a company, you are an outsider. You want to you have a contract with me, either as a shareholder, as a debenture holder, as a supplier, as a creditor, anything. So you, as an outsider, are supposed to read all the documents, the memorandum, the article, and accordingly judge that whether whatsoever you are thinking in the contract is actually in the powers of the company or not. So the constructive notice doctrine is actually a power to the relaxation to the company, and it is a liability on the outsider that whenever they will have a contract with the agreement with the company, they are supposed to read all the memorandum and articles points and understand its effect on their contract. At the later stage, you cannot claim to the company that I had not understood the memorandum. No, this is not allowed in the law. So the lawmaker has given an advantage to the company and a liability upon the outsider, that the outsider will pay very clear attention to what is written in the memorandum and articles, and they will contract with the company accordingly. You cannot deny the fact at the later stage that I was unaware of something which is already incorporated under memorandum. So, which is already defined. At the later stage, if you can prove that I have read the memorandum, but now the company has contravened something which is not mentioned or which is actually deliberately hidden in the memorandum, then you are having an advantage. But on any ground which is already mentioned in memorandum, it is a notice, constructive deemed notice to the public that if you are contracting with the company, you have read all the documents carefully. So this is a constructive notice. A company is a public document, public body. The memorandum and articles are public documents. You are assumed that the outsider who is involving with the company for any business has gone through the documents, right? So it is an advantage to the company and a liability on the outsider that you will read all the documents carefully before agreeing into the memorandum, before agreeing into any contract with the company. So this is actually explained in the next paragraph, that these documents are the charter documents. The doctrine puts an obligation to the outsider to inspect and well verse with these two documents before entering into any contract with the company. Don't come to us after the contract saying that I had not read or understood the memorandum. You must have read, you must have clarified each and everything with us or with anybody regarding the points in the memorandum and article before entering into contract. Simple. That is the constructive notice. Now, a clear-cut exception to the constructive notice is the second doctrine, that is Indore management. This is actually something which is contradictory, or which is against, or which I can say completely opposite to the constructive notice. Constructive notice is basically an advantage to the company and a liability on outsiders, that they need to comply, they need to understand the effects of amendment. But now vice versa. The Indore management is something which is an advantage to the outsiders and a liability upon the company insiders, the directors and the members and the company itself. Now, what is written in the doctrine of Indore management, that the nature of Indore management is completely opposite to the constructive notice. How? The doctrine of Indore management says that, now I'm reading this paragraph, that the person getting into the contract with the company which operates in good faith, that means that person operating in good faith, he shall not suffer by the illegal actions of the company. Basically, what this particular point is all about, say, for example, I had read the documents, I had relied on the facts which were mentioned in the documents. Now, it is not on the outsider to check the validity of the clauses written in the memorandum and article. Say, for example, you have written in the memorandum that our authorized capital is so and so. Our articles are defined that you have this power or that power. Now, if I had read and relied upon that fact, it's not my fault. That you are actually not following those clauses which are actually mentioned in your memorandum and article. What is my fault as an outsider? Had gone through your documents in which it was written what you are entitled to do and what you are not. And if you are not following your own internal bylaws, you are not following your own memorandum and article, it is not the fault of the outsider. So, in the court of law, if I can prove as an outsider that I had relied upon something which is mentioned in the memorandum and article, so I will be treated fairly in the court of law, right? If you say that we are not following the memorandum, so it is your fault. You are not following the article, it is your fault. If I as an outsider has relied upon the documents, now if you are saying that our company doesn't work in the manner which is actually defined in the articles, that is your fault. If you have changed your working, if it is not being reflected in the memorandum or article, your memorandum or article have not been amended in the last few months or years, you cannot say कि ये तो पुराना आर्टिकल है, ये तो हम करते ही नहीं, हम तो ऐसे काम करते ही नहीं, हम तो किसी और तरीके से काम करते हैं. This is not acceptable because I as an outsider has relied upon your document, and whatsoever your document is reflecting, I will be entitled to claim. You cannot say that our internal policy is different than what is defined under memorandum and article. So this is a privilege which is given to the outsider. What was constructive notice all about? This is a obligation on the outsider that you have gone through the memorandum and article. You had understood the implications of all the clauses of the memorandum and article. But this is a complete exception, the Indore management. Here, the outsider has nothing to do with your internal policy. Once I can prove that I had read all the documents carefully, I had gone through the memorandum and article, then my liability ceases to exist after that. Now you need to pay the compensation if you are not following your memorandum and articles. This is basically the doctrine of Indore management. Now, the very basic 2-3 things. The last doctrine we have is the doctrine of ultra virus. Ultra virus. Virus means the powers. Ultra means beyond the powers. Intra means within the powers. So the acts of the companies are either ultra virus or intra virus. Intra virus means within the capacity, within the powers of the company. Ultra virus means outside the powers of the company. The powers of the companies is basically defined by the memorandum. See, to clarify it, I had made this point into four categories. I have categorized this point into four parts. First is, if the company is doing something which is beyond the Companies Act, that means you are doing something illegal, which is already like outside the Companies Act. That is particularly illegal. So those contracts are void ab initio because it has no place in the eyes of law. It is void from the beginning. But there are certain acts also which are ultra virus the memorandum. Probably what I'm trying to say is these are intra virus the Companies Act. They are valid, legal as per Companies Act. We are not doing something illegal, but they are not mentioned in the memorandum. Right? So you have done something which is outside your memorandum. So there will be two cases. Either the ultra virus part and the intra virus part can be separated. Are there a group of contracts, series of transactions in which the ultra virus and intra virus contracts can be separated? If there is so, if you can separate both the acts, then intra virus act will be valid and ultra virus act will be invalid, that is void. However, if there are a series of transactions of ultra-virus and intra-virus acts, but they cannot be separated, then in that case, the entire act will be treated as, of course, ultra-virus, and it will be treated as a void agreement. Simple. There can be certain acts which are ultra-virus, the articles, see this point, but intra-virus, the companies. That means the ultra-virus means beyond the powers of the articles, but the companies or memorandums powers are there. That means there is a discrepancy, but that is not illegal. So what we can do is we can ratify the contracts. Ratification means to make good the contract, to subsequently make the contract valid with the procedure of approval of shareholders. So you can call a general meeting and you can make alterations in that effect. Even retrospectively, the contracts can be ratified by the shareholders to make good a defective contract. So if the shareholders ratify that contract, the company is binding for that. If the shareholders diffuse or denies to ratify, the directors or the persons who have entered into such contract will be personally liable. So this particular portion is actually on the discretion of the shareholders whether they want to bound the company for a particular transaction or not. If the particular transaction is ultra virus, if the particular transaction is ultra virus, the acts of the articles, right? And the last thing we have is it is such acts which are ultra virus the directors but intra virus the company. Means the memorandum states that a unanimous board resolution was required to do such act. It's okay. But the board resolution was passed with a simple majority. So it is the carelessness of or default on the part of directors. Company was entitled to do the work, but the directors were not. The requisite majority of the directors were not there. Or I can say a single director entered into a contract, whereas the lawmaker or the memorandum has defined the board resolution will be required. A single director just came into a contract with. Then also the company can ratify if they believe that such a contract, even though it was a breach of condition by the director. But if the members of the company feel that such a contract can be ratified in the benefit of the company, then the company can ratify it by passing a shareholders resolution. And in that case, it will be binding on the company. But if the members refuse that no, we are not interested, then the director will be personally held responsible for that particular transaction. So that is why we need to say that the outsider shall also pay very much attention to what is intra-virus and what is intra-virus the company in order to protect themselves. So this is the doctrine of ultra-virus.